Hello and welcome to this webinar entitled Drafting Enforceable Commercial Contracts, Core Principles for Lawyers with me, Keith Markham. Let's begin by having a look at the agenda for this session today. So we'll start by looking at good faith clauses. So we're talking about express duties of good faith that are found in the contract. We're going to look at how the courts will interpret those, and in particular we're also going to look at recent guidance on the meaning of good faith itself from one particular case. After that, we'll then move on to talk about endeavours clauses. So we'll look at a variety of phrases like reasonable endeavours, best endeavours, all reasonable endeavours. We'll also look at phrases like reasonable efforts and best efforts and think about how the court might choose to interpret those things. We'll then talk about exclusion and limitation clauses. Now, on other occasions, as you may have seen, I've done a whole load of sessions on this, entire sessions on this topic. So we're not going to go through every last aspect of those two things, of those things today. However, we are going to look at one example of an exclusion clause and one example of a limitation clause that have been recently interpreted by the courts and think about what lessons we can learn from that. We'll then talk about notices. This is often a clause, the notice provision is often overlooked, and that can sometimes have catastrophic results in terms of invalid notices, meaning that a claim cannot be proceeded with and so on. We're going to look at two aspects on this. We will look at, first of all, the meaning of the word day. So often we might see requirements that say, you've got to do this not less than 5 days beforehand. Well, how does the court actually look at what day means? And then we're going to look at in writing, which of course is a perennial favourite. Does that include email? Does it not? And also, when we've got a variety of clauses in the agreement that might talk about how notification is to be provided, which one will take priority, we'll look at that particular issue as well. Then we will move on to talk about entire agreement clauses, and we will think about the wording that we need to cover all of the relevant aspects of that. And we'll also see there's been a recent case that deals with entire agreement clauses in kind of the context of them being used almost as a kind of prevail clause, as we'll see. Now, you may know what a prevail clause is, but we'll see the detail of that a little bit later. We'll then talk about variation clauses. So essentially the same old issues that we see on this, are we able to have an oral variation if it's backed up by conduct and so on? And we'll see what the case law says on that. And then finally, we're going to talk about jurisdiction and applicable law and think about the importance of having those clauses. And also we're going to think about what happens if those clauses are not there as well. So those are the topics that we're going to talk about. So having looked at that by way of introduction, let's turn to the first of these clauses, which is the issue of good faith. And let's talk about this particular case of Matière and ABM. Now, this is a case, folks, that's to do with HS2. So what could possibly go wrong with it? Well, you're about to see that quite a lot. And these two parties end up suing each other for all manner of reasons. And one of the issues that we see in this case is the issue of good faith.